Suspension of proclamation and period for filing of election protest. Section 248 of the Omnibus Election Code reads, Effect of filing petition to annul or to suspend proclamation. The filing of the Commission on Election of a petition to annul or suspend the proclamation of any candidate shall suspend the running of the period within which to file an action protest or quo warranto proceedings. This provision covers the filing of pre-proclamation controversies. This is clear from Section 242 of the Code, which reads, Commission's exclusive jurisdiction of all pre-proclamation controversies. The Commission shall have exclusive jurisdiction of all pre-proclamation controversies. It may motu proprio or upon proper petition, and after due notice and hearing, order the partial or total suspension of proclamation of any candidate elect or annul partially or totally any proclamation which one has been made, if one has been made, as evidence shall warrant in accordance with the succeeding sections. The suspension of statutory period for filing an election protest until such time as the Commission on Election has finally decided the pending pre-proclamation controversy is but logical and just, since if the Protestant prevails in the pre-proclamation controversy, there would be no further need for him to file a regular election protest. Okay. So, hindi jud ay isuspend ang statutory period for filing an election. Okay. The filing of pre-proclamation controversies under Section 248 of the Omnibus Election Code, however, is not the only ground for suspension of proclamation. The two other instances, as provided in RA number 6646, known as the Electoral Reforms Law of 1987, vis-a-vis. So, mo na ni ang two grounds. 1. Under Section 6 of the statute, the COMELEC may, upon motion of the complainant in an action for disqualification, suspend the proclamation of the winning candidate if evidence of his guilt is strong. And 2. Under Section 7 of still the same law, RA 6646, Electoral Reforms Law of 1987, ang second nga ground is under Section 7, COMELEC may likewise suspend the proclamation of the winning candidate if there is ground for denying and canceling his certificate of candidacy. These actions are in the nature of pre-proclamation controversies, and therefore, like pre-proclamation contest, their filing is a ground for suspension of proclamation, and subsequently the period for filing either an election protest or a petition for quo warranto. An order of the COMELEC suspending proclamation is merely provisional in nature and can be lifted when evidence so warrants. It is said to be akin to temporary restraining order, which a court can use ex parte under exigent circumstances. Distinction between action for declaration of failure of election and pre-proclamation controversy. So, lain ra jud ang failure of election and pre-proclamation controversy. An action for a declaration of failure of election is not in the nature of pre-proclamation controversy. While COMELEC is restricted in pre-proclamation cases to an examination of the election returns on their face and is without jurisdiction to go beyond and behind them and investigate election irregularities, the COMELEC is bound to investigate allegations of fraud, terrorism, violence, and other analogous cases and actions for annulment of election results or for declaration of failure of elections, as Omnibus Election Code denominates the same. Thus, COMELEC, in case of actions for annulment of election returns or declaration of failure of elections, may conduct technical examination of election documents and compare and analyze voters' signatures and fingerprints in order to determine whether or not the elections had indeed been free, honest, and clean. Needless to say, a pre-proclamation controversy is not the same as an action for annulment of election results or declaration of failure of election. Next is remedy after winning candidate has been proclaimed. So, unsay remedy sa complainant if naanay na declare nga candidate, nga winning candidate? First, electoral protest before proper forum. After proclamation and assumption of office by the candidate whose election is contested, a pre-proclamation controversy is no longer viable and should be dismissed. The proper remedy being an electoral protest before the proper forum. Okay. So, sa wa pa bali na declare or na proclaim nga winner any controversy or pre-proclamation, if na declare mo na nang ang proper ng action is an election contest. Okay. Instead of submission of mere affidavits, the parties would be able to present witness subject to the right of confrontation. Recourse to such remedy would settle the matters in controversy and subsequently and once and for all. Where an election official has been duly proclaimed, where an elected official has been duly proclaimed and has taken his office, is entitled to all the right of said office until his or unless his election is annulled. Therefore, his exercise of his rights as such official can in no way cause any irreparable injury or violate the right of the losing candidate so as to justify the issuance of a temporary restraining order to maintain the status quo. So, if naka-take oath na ang proclaimed winning candidate, wala na siya na violate nga right sa losing candidate, and therefore dili justified ang magpa-issue ang losing candidate og TRO-han bali niya ang winning candidate. So di na pwede. Another remedy, when proclaimed candidate may still be unseated. So while proclaimed na siya and any controversy pertaining to his election after proclamation are already considered election contest, pwede gapan siya ng unseat. Although already proclaimed and installed in office, the prevailing candidate may still be unseated. 1. When his opponent is adjudged the true winner of the election by final judgment in a court in the election contest. 2. When the prevailing party is declared ineligible or disqualified by final judgment in a court in a co-warranto case. 3. The incumbent is removed from office for cause or when the proclamation is null and void. For in such case, the proclamation is no longer at all and for the proclamation is no proclamation at all and proclaimed candidate's assumption to office cannot deprive COMELEC of the power to make such declaration of nullity. Next, contested composition or proceedings of the Board of Canvassers. Parties adversely affected by a ruling of the Board of Canvassers on questions affecting the composition or proceeding of the board may appeal the matter to the Commission within 3 days from a ruling thereof. The Commission shall summarily decide the case within 5 days from the filing thereof.